My discussion is going to deviate from the frequently asked question format our office has been following for these videos. Instead, I'm going to briefly discuss a seemingly benign change to the Act and put a spin on it that I don't believe you have heard before. Specifically, in the recent changes to the Act, the requirement that all employees prove that their injuries occurred in the course of their employment and that their injuries arose out of their employment was codified for the first time. While that requirement always existed in case law in Illinois, it was never actually in the statute. While most commentators have attached little or no significance to this change, I think it could have a profound impact on defending some cases involving traveling employees. By way of background, the courts have basically eliminated the requirement that traveling employees prove that their injuries arose out of their employment. Instead, courts have merged the "in the course of" requirement and "arising out of" requirement together and established that all traveling employees need to prove to receive benefits under the Illinois Workers' Compensation Act is that the activity they were performing when they were injured was foreseeable to the employer. This concept has always bothered me because, in my opinion, the whole purpose behind the traveling employee doctrine is to expand the concept of an employee's workplace to ensure that traveling employees are afforded the same protections under the Workers' Compensation Act as employees that don't travel as part of their job duties. Instead, under the court-created foreseeability doctrine, traveling employees are actually afforded more protection than non-traveling employees. For example, if a non-traveling employee is walking from his workplace into an employer-controlled parking lot and he trips on a curb in good repair, his case would not be compensable under the Caterpillar holding. If that same employee was a salesman or repairman who traveled as part of his job duties and broke his ankle in exactly the same way visiting a client location, his injury would be compensable because it would certainly be foreseeable to his employer that he would need to walk from a client location to the parking lot where his car is parked. Now that the requirement that all employees need to prove that their injuries arose out of their employment is in the statute, and there is no exception in the statute for traveling employees, employers can argue that the court-created foreseeability standard is no longer viable and was superseded by the changes to the Act. Otherwise put, the employer could assert a defense based on the Caterpillar holding to the salesman or repairman's ankle injury in the fact scenario I previously outlined. In conclusion, this development potentially provides employers a strong defense to a traveling employee case where a potential defense that the petitioner's injuries did not arise out of his employment exists. If you have any questions or comments about the content of this video, or if you have a case that this analysis applies to that you would like to discuss, please contact me at 312-346-5314. Thanks.